Ready to.
So, all right, here we are. Ready to rock and roll. We are going to present Estoppel and fraud. This is what we're going to talk about tonight. Because remember, keep in mind, whatever one does in his defense, he is considered to have done legally, right? So, of course, barring that you don't kill anybody or, do anything stupid. I'm going to shut that video down so it doesn't get in the way there. All right, so we are going to play a little bit of Monday Night Law, just you, me, and the boys here tonight. This is if you want to, donate to us. This is our addresses. There's Kirk's in Idaho at the office, and of course mine here at my office. And there is the PayPal and Cash App information. I'll put this back up at the end of the PowerPoint, so you guys will have more time to jump into that. But we are a lawfully created corporation under the laws of the state of Florida and the laws of the United States. Also been granted a standing mandate to do this by the appellate court. The judge said it's about time somebody went in there and told these guys they can't do this, because apparently we must be speaking pig Latin over here at the court.
Right.
So, maybe you'll have better luck, right? So it's like, okay. So this is basically follow the law and the rules of the court. Pretty standard, right? Pretty easy stuff, right? So as we follow due process of law through the legislative remonstrance process in pursuit of emoluments violations. Ooh. So here we go. This, of course, we remember. We went through this on the was the Veterans Day show. This dates all the way back to the First Continental Congress, right? Anytime anybody has a grievance against anything that happens within their government, we assemble a Congress, right? So, we talked about the monopolies and all that stuff. So, of course, being a couple of gearheads, we got to put our public service message together. So here's our public service message. To avoid injury, if you walk into the shop and see your guy has these tools out, avoid eye contact and back away slowly. This has been your public service message. So just so you know, that was a little joke in case you missed it. Flew right by you. So anyway, meanwhile, back at the ranch, we are going to deal with an issue, or this process is all based in time, right? A lot of times when you go in, anybody who's ever given a presentation in a boardroom knows that you have a certain amount of time to catch for two things. Number one, you got to catch their attention. And number two, you got to keep their attention. So knowing and understanding people's attention spans grow shorter and shorter and shorter as time goes on. So, when you're going through and you're making your notes, don't be afraid to put all your information into an initial document and reread it later to pick out the most important facts or elements of signification. This will help you remain focused as you proceed. And tune in Wednesday, because I'm going to talk more about debating, right? Once you get through the initial quorum and make your presentation, the debate follows. But right now, we're worried about preparing, right? Exactly what you're going to throw at them and why. So, as I said in the title page, what one does in his defense is considered legal. So let's start with affirmative defenses. What are the source materials? Must be credible, verifiable, to the person or persons you intend to make your presentation. Most readily available sources are court rules and legal dictionaries, right? So these are the two most commonly used. So starting with the federal court, right? It's the supreme law of the land, but the minimum level of due process. So in your federal rules, then under Rule 8, affirmative defenses, C1. In general, in responding to a pleading, a party must affirmatively state any avoidance or affirmative defense as follows. And again, this is the reason I chose this legal maxim. So those are accord and satisfaction, arbitration and award, assumption of risk, contributory negligence, duress, estoppel, failure of consideration, fraud, illegality, injury by fellow servant, right? This is where participating in the quorum comes in. Latches, license, payment, release, res judicata, double jeopardy, basically, right? Statute of frauds, statutes of limitations, and of course, waivers. So here's your list. This is primarily, mostly where you should be working within. And this video is going to deal primarily with the two that are highlighted in red, and you guys are going to see that why as I go down through. So in legal dictionaries, right? 11th Black's Law, 10th and 11th. I mean, these things come in all shapes and sizes. You know, here's Bovier's, and you know, so much of this presentation will be centered around the usage of estoppel, as this topic seems to be the most confusing, based on other email and other feedback I've received on my published remonstrance pertaining to the defense posture of the document. You know, everybody says, well, you should be able to prosecute your own cases. Well, you have to effectively defend first. So what I did was I took out of Bovier's and I created, because estoppel is actually on 2 pages, so I created this slide, and this is exactly everything that Bovair says about what estoppel is. Okay, so it's kind of general and vague, but you got to remember this edition is what? Dated, revised edition 1856. So I think we've made some progress since 1856, don't you?
Yeah, but you know, I love Beauvair's Law Dictionary from 1856 because it lays out the common law in there.
That's right. And you know, when you start getting into the difference between positive law, statutes, you know, statutory word salad, which leads to rules and other SMU, okay, that's the reason I put this slide in here, is because, you know, try to help you guys separate the real from the fiction. So going back to the beginning, this is actually, you know, fairly real. But again, as I've said, we have expanded on this in other versions of dictionaries. So, you know, my remonstrance has these 3 estoppels built into it. Inequitable, which is as a defense doctrine, preventing one party from taking unfair advantage of another when, through false language or conduct, the person to be estopped has induced another person to act in a certain way, with the result that the other person has been injured in some way. So, misrepresentation. One of the reasons that this works, again, is these 3 being used by somebody who's actually licensed, by the way, is it's kind of like taking a hammer, you know, and driving an attack with a sledgehammer. You know, I think it's unnecessary, but apparently, you know, it is what it is. So misrepresentation is an estoppel that arises when one makes a false statement that induces another person to believe something, and that results in that person's reasonable and detrimental reliance on the belief, right? Scheme, scam, fraud, snake oil salesman, pillars of law that don't exist, processes of law that don't exist in our republic, you know, and of course, negligence, estoppel by negligence. This is an estoppel that arises when a negligent person induces someone to believe certain facts, and then the other person reasonably and detrimentally relies on that belief, right? So this is what we say one of the troubles with monopolies is when there's no defense mechanism. When I say the people are defenseless, hey, who's giving the rebuttal argument here? And the answer was, looks like it's all you, bro. And I'm like, okay, fine. So this is in Black's Law 11th. I'm going to read number 3 here because number 3 is probably one of, is basically the definition that I used, within the document, because it was basically as an affirmative defense alleging good faith reliance on a misleading representation and an injury or detrimental change in position resulting from that reliance, right? So that's why I say all this stuff being on my testing, that's why I said learning how to use this stuff, it was like fractal calculus. It's almost, it's very, very difficult. And much like Beauvair's, in the Black's Law 11th edition, this bottom section here does go into and explain quite a bit of, the common law and public law. So there's even some case precedent in there that is still good case precedent today, because this is the new 11th edition. So all the definitions that you guys are going to see tonight are from this edition. So nobody can say, oh, this is old. No, it's not old. This is what's currently being used. This is the brand new one. So yes, Valerie, the Zoom number 848-973-346. Please join us, and please join without video and audio, if you don't mind. We greatly appreciate that. So equitable estoppel, just went through equitable estoppel. Those of you who want to know further what the 5 separate definitions of equitable estoppel are, this is actually it. You see, I use number 1, right? So jump into fiduciary usage. So again, use a couple of legal maxims: uses of fiduciary ownership, and of course, a concealed intention is an evil one. So what is that? ERISA estoppel, which is an acronym, ERISA, arising from a written misrepresentation in or about an employee benefit plan or a fiduciary. Okay, so those of you who do have grievances against fiduciaries, whether they were bar members or whether they were bankers, it is irrelevant. Okay, that you may want to research this acronym and research this estoppel a little further, right? So that'll help that'll keep them at bay as far as unlawfully claiming, exercising powers and pillars of law that don't exist in our republic. So, because kind of remember, estoppel's intended purpose is kind of like put your hand up. Hey, quit doing that. You're not supposed to be doing that. Why are you doing that? So by agreement, estoppel based on the terms of a contract between the parties expressly implied, showing a mutual acceptance of certain facts or assumptions. And estoppel by contract, right? Because we say, a lot of these guys say, oh, I have a contract. Really? Okay, well, let's look at estoppel by contract just for a second, because this is a bar that prevents a person from denying a term, fact, or performance arising from a contract that the person has entered into. Okay, well, can you prove that I entered into that contract? If you can't prove that I entered into that contract, I'm gonna apply an estoppel on you, right? Because you're claiming exercising rights you don't have based on a document that doesn't even exist. So, and we see this a lot in transactions, which is one of the reasons why I chose this maxim. Transactions between others can benefit, but should not injure anyone who is not party to them. So if they're claiming they have a contract and they don't have your signature on that contract, you're not party to that contract. It seems almost simple stupid, to have to employ something of this magnitude, but apparently that's the world we live in as it is right now. So moving on. This actually will lead you to fraud in the inducement. Now, I'm breaking with a little tradition here. I was going to go all the way down through Estoppel, but this was, this was important because when we're talking about the contract, okay, they have induced the court to believe that they have this contract with you when they can't produce the contract. So, again, page 25, section 16. Well, there's your fraud or bad faith. Fraud occurring when a misrepresentation leads another to enter into a transaction with a false impression of the risks, duties, or obligations involved. An intentional misrepresentation of a material risk or duty reasonably relied on, thereby injuring the other party without vitiating the contract itself about a fact relating to value or the ability to perform. Well, again, because we already know that they don't have the contract. So, the fact that they've induced, like, for example, a kid's mother, well, yeah, just sign this paper and we'll go get the money back from dad. Well, that's claiming and exercising a power they didn't have to begin with. So they induced her into this signature, which, come to find out, it wasn't even her signature. And, this is one of the reasons that we've created this. And of course, here's page 25, section 16 again. So you guys can have that as your, kind of your basis and your guideline as we move through this. So when we go through performance, again, actual licensed professionals, this is on the test. So I want to share it with you guys. Actual performance dating back to the 16th century. This is the successful completion of a contractual duty, usually resulting in the performer's release of any past or future liability. So, in other words, once you pay for that big screen TV and you turn around and you walked out the door with it with your receipt, you have completed the contract, right? So you gave your debt notes and you walked out with a big screen TV. Yay, everybody's happy. So defective performance is a performance that, whenever partial or full, does not wholly comply with a contract. Ooh, right? How many of you have read Nate's case? I specifically cite defective performance and even a little bit of misperformance, which I'll get into in a minute. But because there was, when we go in and we hire this bar member person who says, oh, I can do this job. Those dirty bastards, they can't do that, blah, blah, blah. Give me $10,000 and I'll do whatever you want me to do. And they come to find out they don't do nothing. So that is an example of defective performance to an actual licensed professional anyway. So, and of course, misperformance is from the 17th century. A faulty attempt to discharge an obligation, especially a contractual one, or non-performance. Well, again, if the contract that was drawn up clearly contrary to law, what I cannot do in my person, I cannot do through the agency of another. These are things that we know as licensed professionals. So we know that, we can't write contracts that are contrary to the law. And this is the reason. Always in doubtful cases, that is to be done by which a bona fide contract may be the safest condition, except when it has been drawn up clearly contrary to law, right? So when you go in and you say, what law are you contracting under? And if that law is not Republican in character or form, your contract and everything that you just claimed is void. How do we know that? Because this is our style and form of government. It better be, whatever contract you write, better, number one, be in full disclosure, right? I talk a lot about truth in lending statements, right? So, for example, a truth in lending statement is when you go get a mortgage, your banker gives you this what's called a T&L, truth in lending, of how long that mortgage is going to last, what the amortization or payment schedule is, and exactly how much you're going to pay throughout the entire term and condition of that mortgage, that contract, right? So I said these are required elements of a contract. When you notice, you can't even get these guys to even say, what's your policy? They want to give you a copy of their policy. So how can you even stand there and even argue that the contract coming out of your office is lawfully created when you can't even show what was the criteria you used to create it, right? Where's the disclosures here? So, and of course, you've all seen my litmus test. So I've been down through this in a complete video. I do have it on good authority. This is on every politician's desk, thank God. And, this is why we're starting to see, pay very, very close attention to what's going on C-SPAN right now, because the House of Representatives has commenced the Finance Committee to go through and start re-examining a lot of these contracts. They're starting to cut these guys off, right? So because we sent this up through Secret Service, they have oversight into the financial mechanism. They report to the Finance Committee, right? This is chain of command. This is knowing how these things work. So, Congress is going in and they're pulling these actors from these sub-agencies and saying, hey, you're going to have to show me something here, right? Because if you're not going to show me nothing, we're not going to keep paying for this. So this is when we go into the whole bar smew and the conduct of the conduct of a tyrant, right? So let's go down through some of this a little bit and see if this doesn't sound familiar to you. For transporting us beyond seas to be tried for pretend offenses, Schiff made up, right? For abolishing the free system of English laws in a neighboring province, establishing therein an arbitrary government, and enlarging its boundaries so as to render it at once an example and fit instrument for introducing the same absolute rule into these colonies. Imagine that, boy. And you guys wonder why I love the Declaration of Independence.
Mm-hmm.
For quartering large bodies of armed troops among us. For protecting them by a mock trial from punishment for any murders which they should commit on the inhabitants of these states. Let's see here. Here's one. You've seen us talk about this one.
This is one of my favorite ones right here.
Right here. Yeah, right. He's erected a multitude of new offices, sending other swarms of officers to harass our people and eat out their substance. Right. He has obstructed the administration of justice by refusing his assent to laws for establishing judiciary powers. He has kept among us in times of peace standing armies without the consent of our legislatures. He has combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, giving his assent to their acts of pretended legislation. Remember, quadrant number 4, right? The negative nexus between the fourth and the fifth pillar. So anybody out there dealing with real property transactions right now, this one you want to pay particular attention to. This is estoppel by deed. Okay, so this is estoppel that prevents a party to a deed from denying anything recited in that deed if the party has induced another to accept or act under the deed, especially estoppel that prevents a grantor of a warranty deed who does not have title at the time of the conveyance, but who later acquires title from denying that he or she had title at the time of the transfer. Now, I understand that sounds confusing, and it does sound even odious as it goes on to further say. But this is this is a pretty effective one in transactions of real property. Here's the reason. Where's the title? Where's the actual title to that property? Because if they can't produce it, how are they creating a deed, a transfer instrument on a document that they can't even produce, which is the title itself? So, this is what I'm saying. This is what I'm trying to help you guys understand, that these things are very complex, and, further study is, of course, definitely warranted. But the baseline comes from the dictionary. So, estoppel by election, not really that important under the context of what we're doing. Latches. This is one of those affirmative defenses, right? In 1894, an equitable doctrine by which some courts deny relief to a claimant who has unreasonably delayed or been negligent in asserting a claim. Right? These bar members walk in with their shift made up, but they don't have a remonstrance, right? They usurped a power. They walked in and got this warrant that they weren't entitled to. So that would be that could be a misrepresentation, could it not? Estoppel that arises when one makes a false statement that induces another person to believe something that results in that person's reasonable and detrimental reliance on that belief. So negligence. Now we talk about there's a difference between misrepresentation and negligence. So what's the difference? Well, here's the difference. An estoppel that arising when a negligent person induces someone to believe certain facts, and then the other person reasonably and detrimentally relies on that belief. So, that video that we watched, Kirk, with Kim Picasio and her circular argument, right? She wouldn't even go tell you what the hell she thought domestic violence was. And then when you finally backed her into a corner, right? Oh, in 2019, it means, well, hold on, back the truck up.
This is what I put in the brief for Tim's case was, does Congress have the authority to alter, redefine words in the Constitution?
That's correct. That's a mischaracterization.
Anybody of sound mind knows, right, that you don't, that Congress does not. And I've supplied the law behind that, the Law of Nations, written by Amr D. Patel.
Sure.
Book 1, Chapter 3, Section 34. That question has already been answered before our government was even instituted.
Right.
Right? No, Congress does not have the authority to alter the fundamental law or the Constitution.
Right.
Because the Constitution institutes and creates government. Those members of Congress are servants, right?
Right.
The Constitution creates their emolument, their seat in government. How is it then that those that are sitting in, and this is explained in Book 1, Chapter 3, Section 34, is how is it that those people that has been created, how do they make it so that they can alter what the law of their creation?
Right. And they can't.
That's just like fundamentally, principally unlawful, wrong.
Right. So, that's actually
the law of your creation.
So let's go into the next two, because what you just basically stated leads us right into the next two versions of estoppel, correct? So representation is an estoppel that arises when one makes a statement or admission that induces another person to believe something that results in that person's reasonable and detrimental reliance on the belief. So, and then of course by silence is one that arises when a party is under a duty to speak but fails to do so. Right? So you're in this position of emolument. You have been petitioned. You did not speak. Right? So that means, guess what? You've just agreed to what I've spoken because you didn't rebut. Silence by acquiescence, acquiescence by silence. So, which is, of course, further in the book. But if you put forth a document and they don't respond, right, you can stop whatever they're doing by issuing an estoppel by silence. And here's where it comes from and why. So some of these other subcategories, as you notice, for example, estoppel by warranty, it says see estoppel by deed, right? The previous slide. So, you know, because deeds are issued with and without a warranty. So you see what I'm saying? This is one of the reasons why you kind of have to know the language of, you know, what works together and why. So, you know, estoppel on the record, see prosecution history. Okay. Could there be something to the effect of a nolo prosequi, right? Which is, you know, there's no standing to prosecute. Judicial estoppel, right? So this one is unique. This comes from 1856. This is an estoppel that prevents a party from contradicting previous declarations made during the same or earlier proceeding if the change in the position, in position would adversely affect the proceeding or constitute a fraud on the court. Whammo, right? So you'll see a lot of times, even the judges will come out and say, do you want to retract that statement? Because, you know, you could find yourself in a serious amount of trouble here, or you could find yourself in a dismissal situation of the claims that you're alleging if you're going to stand there and you're going to lie to us, right? So this is sometimes confused with legal estoppel, right? Recognized in law as distinguished from equitable estoppel or estoppel in, Payas? So, such as an estoppel resulting from a recital or other statement in a deed or official record and precluding any denial or assertion concerning a fact. So, you know, this is where you start to separate, right? What you know, what is somebody, what's hearsay, and, you know, what do you believe and what can you prove, right? And of course, marketing estoppel, which goes into patents, right? And those of you who are going to go into patents, you guys will probably want to look a little more into that. So when we go into principal and agent, okay, this legal maxim again is very prevalent in the Principles and Practices book. Common opinion is double, that proceeding from grave and discreet men, which has much truth in it, and that proceeding from foolish and vulgar men without any semblance of truth in it. So you see what I'm saying? This is where, this is where you can get into something like a promissory estoppel, which is the principle that a promise made without consideration may nonetheless be enforced to prevent injustice if the promiser should have reasonably expected the promise to rely on the promise, and if the promise did actually rely on the promise to his or her detriment, right? So again, you go back to fraud in the inducement, right? Yeah, if you do this, if you pay me $10,000, I'm going to take their ass to court and I'm going to hang them by parts of their body that'll be unrecognizable. And then you get in there and they just kind of sit there like a bump on the log and they're, dude, do you have a pulse? Are you breathing over there? Aren't you supposed to say like, I object or something? Right. So, you know, that's why I said, you know, as I go through this and I think, well, using the baseline of agency practice, which we know is lawful, everybody's acquiesced to that for decades. You know, we've been doing this forever. Prosecution history estoppel, right? Again, going back to patents. I don't know how that slide ended up in there twice, but hey, it is what it is. Quasi, an equitable doctrine preventing one from repudiating an act or assertion if it would harm another who reasonably relied on the act or assertion, right? Because, you know, you can do no harm, right? So anybody in position of emolument, that's like kind of like rule number one, you can do no harm. Oh yeah, and you can't lie. So
Wait, you can't lie?
I-
Any
Isn't that
official
that?
with an any official with an IQ greater than room temperature in Alaska knows that you can't lie.
Yeah,
They're
it's like,
supposed to know that, right?
well, you would think, it's, it hurts your brain, you know, to think that, oh yeah, this one's going to lie and the other one's going to swear to it. And you expect me to believe that any contract or any jurisdiction that you may have had at once didn't just fly out the door?
Right?
Wrong. So, you know, and let's go into technical, right? Because this is where it starts to get really, really good, because we start getting into technicalities here. So this is an estoppel arising from a matter of record or from a deed made by the party who is claimed to be estopped. Okay. Estoppels by deed or by record are called technical because the rules of estoppel apply with certainty in appropriate cases. So, again, the second definition, you can go back and see collateral estoppel. So, this is why I say these things, you really got to know what you're doing when you do stuff like this, because this kind of thing is, um, you can find yourself going down a rabbit hole if you're not careful. So,
Right.
you know, to grab 3 the way I did, it was like, well, you know, how do I teach people how to do what I did so they can duplicate it? So that's the reason we do this show. Um, One of the most applicable in context in cases involving any form of corporate wrongdoing. Okay. This we get into corporations and actors within a corporation who commit wrongdoing. So someone who relied on an alleged misrepresentation and seeks to have the person who made the representation held liable for the resulting harm or loss. The asserter must be the person to whom the misrepresentation was directly made. Right? So, anybody out there who wants to use this one, you may want to make special note of this one, that because we know these are corporations and da 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 da, the fact that this is used very significantly in cases of corporate wrongdoing, this is a process that is well understood and has been used, like I said, for decades. So, when put this into your document and it's like, even the judge is going to look at this and look at your representative and say, well, yeah, you mean to tell me you don't know what corporate wrongdoing is? And of course, Congress's answer is probably no. So
It's definitely going to raise an eyebrow one way or
yeah,
another, right?
one or two, right? um, so Denier is mentioned in my remonstrance, and here's why. So this is an estoppel denier, someone who allegedly made a misrepresentation to another and seeks to avoid liability for the misrepresentation and show that a contrary statement is true. Again, they've made this allegation that my report didn't exist. Guess what? I have proof to the contrary. I have the cover page in my possession. I have the original cover page, and I have the original substantive order that says that, oh, I was supposed to be receiving child support, not paying it. So the rest of the document must coincide with what the order says, or at least a reasonable person would say that. And of course, we know that that's not what happened because of all other SMU and star chambers and all that other crap. So a estoppel certificate, sorry, went out of order here, is a signed statement by a party, such as a tenant or a mortgage, certifying for another's benefit that certain facts are correct, such as that a lease exists, that there is no defaults, and that rent is paid to paid to a certain date. A party's, I think an example is a party's delivery of this statement stops that party from later claiming a different state of facts. So basically, if your rent's paid, you're good. So And of course, you can go into waiver of that type of stuff. So again, citing, going back to how do we use section 16, page 25, right? Well, are you citing fraud, or are you citing bad faith, or are you going to end up citing both? Right? I mean, it just depends on the context of your case. So in cases where it's very, very, very complex, where we're talking about land deals and contractors are involved and you've got money draws coming out of them, and you know, there's all of these moving parts in there, right? Those kinds of cases and those kinds of audits do take, I mean, those are a pain in the rear end. So let's get into the actual fraud, right? Great fault or gross negligence is the equivalent of fraud. So let's go back to its original root word from Latin from the 16th century, which is deceit or cheating. For example, a debtor who has conveyed property with a significant intent, fros, of defrauding a creditor risked having the conveyance rescinded, right? So that's pretty basic stuff. Fraud in law or fraud on law, right? False leges, so which is evasion of law, specifically doing something that is not expressly forbidden by statute, but that the law does not want done, right? So again, you want to go down the rabbit hole of statutes, have fun with that. Because the problem with it is the quote unquote clear and plain language of the statute. By the time you get done with reading that clear and plain language of the statute, the end of the statute is says, except on Juvember 34th, if you're standing on Mars, on you can use this. Other than that, it doesn't. It only applies wherever the hell we say it applies. And
right,
you're standing there going,
yep.
Dude,
Pick
you must be on
right?
Uranus if you think I'm going to acquiesce to that.
It's kind of one of those situations where they pick and choose what works for them.
Right, exactly. Shift made up. So,
I could have swore that anytime you're going to be construing anything, it must be construed in favor of the clearly intended and expressly designated beneficiary, which is the people.
Oh, yeah.
Ooh, darn. That'd be American jurisprudence, wouldn't it?
That's right. So, okay, everybody, I hope this is the part where everybody has been waiting for, because this is the section on the fraud right here. So let's start with the actual definition of just the word, and we're going to run down through here, and we're going to see its many applications. So fraud, a knowing misrepresentation or knowing concealment of a material fact made to induce another to act in his or her detriment. Fraud is usually a tort, but in some cases, especially when the conduct is willful, it may be a crime. And of course, we get a total of 4 of these, so we'll go number 2.
But that's also termed intentional fraud.
We'll wait till we'll get to that. We'll get to that. Number 2, a reckless misrepresentation made without justified belief in its truth to induce another person to act. Number 3, a tort arising from a knowing or reckless misrepresentation or concealment of material fact made to induce another to act to his or her own detriment. Right? Denial of exculpatory evidence would lead.
I'm hearing like negative nexus there.
There you go. So this could detrimentally lead another judge to act contrary to the truth, right? Which is why they, shuffle judges around on you. Only tell the one who's coming in what they want them to know. So additional elements in a claim for fraud may include reasonable reliance on the misrepresentation and damages resulting from this reliance. And number 4, unconscionable dealing. especially in contract law, the unfair use of the power arising out of the parties' relative positions and resulting in an unconscionable bargain, right? That gets into what? Fraud in the inducement, right? I just talked about this. So that's why I said, as I go down through this, some of you guys, you're probably going to want to, if you're watching this in the replay, you're going to want to go back and forth a little bit, or just maybe watch this couple, 2-3 times, because this is so intricate and detailed. So now we're going to get into, there is such a thing as actual fraud. Okay. So a person is considered a possessor who has ceased possession through injury or fraud. This is a maxim of law, right? So a concealment or false representation through an intentional or reckless statement or conduct that injures another who relies on it in acting, right? So when you're preparing your statement to Congress, okay, or to court or to wherever, if you're going to cite it, going through and putting the definition, the actual language of the definition, ain't going to hurt you, right? So that's one of the reasons that I do that in context. It's like, hey, don't take my word for it, dude. Go verify it. So this is true in context of every case involving child support. Right here, advanced fee fraud. This is a criminal fraud in which the victim is persuaded by the perpetrator to pay fees in anticipation of receiving a much larger benefit that is ultimately never delivered. Right? Who the hell gave that welfare state of Ohio the right to go in and take $80 out of every $100 bill that I sent my kids? Wrong. The perpetrator usually claims to have or to represent someone with a large sum of money that must be immediately transferred out of a foreign country, or some compelling, for some compelling reason, such as to avoid seizure by a government. The criminal promises the victim a portion of the money in return for the victim's agreement to open a bank account in the victim's name. You guys have had these scam calls before. You know what I'm talking about. So the victim must then pay upfront fees to the designated bank and others, although the internet has become a favorable tool for this fraud. It has been around for years, beginning with handwritten or typed letters and later faxes. Because advanced fee fraud is believed to have originated in Nigeria, it is also termed 419 fraud, after the section of the Nigerian Penal Code designed to punish those who defraud by this method. So, now we're getting into those foreign emoluments, right? So, let's see here. I'm trying to get in private messages here on Facebook as I'm trying to watch comments. Sorry guys, I don't mean to be rude. I'm not trying to ignore you. I'm just trying to, get through this, because we had a pretty good size, thing to get through tonight. So again, these guys are so busted. There's the numbers. There's the accounting, right? Who the hell is other? Oh yeah, welfare state of Ohio. Wrong. That's a fake entity. That's SMU.
Well, and
right?
if you put it in all capital letters, the state of Idaho would be, or state of Ohio, there would be indicating a corporation. We're not supposed to have corporations in our form of government.
Exactly right. Yeah. So that goes to that subjecting us to a jurisdiction foreign to our form of government, not acknowledged by our laws. So again, because with a contract, okay, with a during your agreement, there must be during the phase of quid pro quo. In that definition, the word reciprocity is referred to, and here's why. In order to have reciprocity, there must be a mutual or bilateral action, right? I've been through this 1,000 times. There has to be an equal benefit or a mutual concession of advantages or privileges for purposes of commercial or diplomatic relations, right? So I said this concept goes back, well, it's actually before the 18th century, but for some reason this only mentions it in the 18th century. Why, I don't know. But it does go further down under reciprocity here, and it does go into some of the, intellectual and property law, and why and where all that stuff comes from. So, interesting read if you feel like going into all that. So, affiliate click fraud. This is typically for website stuff. If you guys are web designers out there, and you want to go down that rabbit hole, it's again, choose your battles, right? That's why I say, do you guys want to fight or do you want to win? So affinity fraud on the other hand is a fraud in which the perpetrator tailors the fraud to target members of a particular group united by common traits or interests that produce inherent trust. The perpetrator often is or pretends to be a member of the group. Investment scams such as Ponzi or pyramid schemes are common forms of affinity fraud. When a religious group is targeted, it is usually called religious affinity fraud, right? So we see this a lot in our groups, right? Out there, whether we're on Facebook or we're on YouTube or Twitter or Instagram. I mean, pick a pick a place where people normally gather and congregate. Okay, this is the confidence man, right? Is the person who's perpetrating this affinity fraud. So bank fraud and bankruptcy fraud are actually two different things. I've had people go through this and they've inaccurately confused them, and I understand why once you've read the definitions. So bank fraud and bankruptcy fraud they are two different things. Please don't get them confused, because you can find yourself in a bunch of trouble for backing and forth. But civil fraud, this usually goes into taxes, tax evasion, and that kind of thing. So again, very, very common misapplied, right? This is a civil case, so it must be civil fraud. Not necessarily, right? So be very, very careful as to what definitions or which modifier you're putting either before or after the word. So people will consider civil fraud with, here's one, common law fraud, which is promissory fraud, right? We went through some of that.
What do you mean, starry-eyed diseases fraud?
Right. And of course, click fraud, we just talked a little bit about that.
Right.
Competitor click fraud, some of that. This is one of Kirk's favorites, by the way, constructive fraud.
Yeah.
This is a unintentional deception or misrepresentation that causes injury to another. Now, here's why it's constructive. Because we're talking about corporate compartmentalization, right? Every compartment is designed to do a specific job. It has no idea that what it is doing is unlawful, right? Because somebody's been asleep at the switch here, or it was designed to do exactly what it's doing, but the person sitting in their little cubicle is just, hey, I'm doing my TPS reports. This is what the screen tells me to do, so this is what I'm doing, right? So this is the unintentional deception or misrepresentation that causes injury to another. So you need to be very, very careful as to how you apply constructive fraud. So somebody who is writing policy for CPS workers, okay, they're the ones who are creating the constructive fraud, right? Because they're leading this CPS worker to do something that, the average person with a IQ greater than the room temperature in Alaska would know and automatically understand that, hey, that's some shift made up. You better quit doing that. So, just to make very, very sure that, these things are also termed legal fraud, fraud in contemplation of fraud, equitable fraud, and of course, fraud in equity. So, these are, I'm going to get back to fraud in law here in just a few minutes, because that's actually coming up. Consumer fraud. Okay. Any intentional deception, deceptive act or practice, false pretense, false promise, or misrepresentation made by a seller or advertiser of goods or services to induce a person or people in general to buy. That's consumer fraud. People will also say, that's false advertisement. That's a good example of consumer fraud, right? So, criminal fraud. Now, again, a very, very limited definition. You need to be very careful how you use this, because using it wrong could land you in trouble. Okay. So criminal fraud is fraud that is illegal by statute and may subject an offender to criminal penalties such as fines or imprisonment. An example is the willful evasion of taxes accomplished by filing a fraudulent tax return, right? So you really need to go through, if you're really wanting to pursue criminal fraud, I highly recommend that you do read a lot of cases and a lot of judicial opinions where criminal fraud was used and applied properly, right? Because we talk about the difference between the dictionary and what stare decisis says. So knowing what, and I'm going to cover that in just a second, fraud in, criminal fraud and its perceptive, its common observance is not necessarily applied that way in the judiciary. So again, that's why I said you need to be very, very careful, and don't confuse it with something like extrinsic fraud, which is fraud that is collateral to the issue being considered in the case, specifically intentional misrepresentation or deceptive behavior outside the transaction itself, depriving one party of informed consent or full participation, right? That's why you got to have the meeting to decide which jurisdiction you're going into. So who the hell had that meeting, right? So, for example, a person might be engaged in extrinsic fraud by convincing a litigant not to hire counsel or answer by dishonestly saying the matter will not be pursued. Also termed collateral fraud. Fraud that prevents a person from knowing about or asserting certain rights. Again, how can you deny somebody, from claiming and exercising a right? That's Miller versus U.S. Can't do that, right? So that's why I said there's a lot of these things that you have to be very, very careful and pay very close attention to what has already been established and how the court currently views it, because you don't want to do it wrong, right? So these are some examples that I see a lot that are related to this, are right here: advanced fee fraud, fraud in law, constructive fraud, and of course actual fraud. That's why I said there's a lot of misapplication of the word because people aren't using the right modifiers to go with it. Now, fraud in law is a fraud that is presumed under the circumstances without regard to intent, usually through statutorily created inferences, right? That's that word salad, right? Fraud may be presumed, for example, when a debtor transfers assets and thereby impairs creditors' efforts to collect sums due. This type of fraud arises by operation of law from conduct that, if sanctioned, would, either in the particular circumstance or in common experience, secure an unconscionable advantage, irrespective of evidence and actual intent to defraud. Remember, I believe it was in the statement of facts number 3, where I had said my liberty interests have been infringed by the intentional inclusion of and intentional exclusion of relevant evidence and testimony, et cetera, et cetera, et cetera. Right. So that was where I was leading into the fraud in law. So this is what I said. It's a matter of, you can say it without saying it, but you can say it better by being a little more descriptive as you're going down through it, using the definition. And then you could say, see fraud in law, right? Or, when you're talking about in execution, fraud in the factum, which I believe we're going to do next here. Fraud in the factum. Fraud occurring when a legal instrument is actually executed differs from the one intended for execution by the person who executes it, or when the instrument may have had no legal existence, right? Those false warrants that we're seeing coming out now, right? What standing in law did they have to get a warrant against Field? I think that was some shift made up, wasn't it? Right? Because there was no right trespassed, right? She admitted in the document that she was more than 1,000 miles away from him. So where was the threat?
Well, not only that, the Fifth Amendment says for high crimes, felonies, that kind of stuff, you got to have a grand jury indictment.
Exactly.
And then not only that, it has to be filed in the district previously ascertained by law where the crime happened.
And what was it you had read? What does the judge have to have in order to sign the document? It has to be where? Within the judge's jurisdiction, correct?
That's right.
So if
in the complaint itself made by the officer,
right,
which he doesn't have standing in law to claim a right to a cause of action,
right.
But in his own statement, it says that this happened in Polk County, Wisconsin, or whatever this town is. Yeah.
Like, where the hell am I again?
We're not in Kansas anymore, Toto.
Right, I hear you, brother. So,
but it's like, it happened right here at his office.
Right.
Right.
Right. So, this again, because this kind of leads me right into where I'm going next. Compared to fraud in the inducement, fraud in the factum occurs only rarely, as when a blind person signs a mortgage when misleadingly told that the paper is just a letter. Right? So, and then of course in criminal law, okay, because we've got to remember there's always a potential for another application. In criminal law, this is in the law of rape, misrepresentation about the nature of the act of penetration, whereby the other party's consent is nullified and the actor becomes criminally responsible. Right? You roofie somebody, right? There's a fraud in the factum. So, at least in criminal law. So, that's why I said to know these things. And this is one of the reasons why in a lot of these cases where I end up, having to go through this is kind of like traumatic for me, right? Because, I'm not a woman. I have, all I can do is write what they tell me to write. And one of the main reasons why, it's very, very difficult for me to read some of this stuff because it's actually very graphic. And, I have to go through and tell Mr. Senator or Mr. Congressman or Mrs. Senator or Mrs. Congressman, there needs to be a level of anonymity here. right? This person does should her anonymity should be respected here, right? So, but then again, that's why I said the whole process is just so conglomerated with junk science, because you know by the time you know he runs through the appellate process, or somebody goes in and tries to rebut it, they're saying, well, some jackwagon out of you know Ethiopia somewhere postulated that if you put these two words together, that could make this statement false, right? And now you got this poor woman who's literally put in the position to where it's not where she is necessarily fearful of facing her accuser. She just doesn't want it on the 6 o'clock friggin' news, for God's sake, right? And I respect that. I have a lot of respect for that. So, not to put too fine a point on that. So, again, let's go into fraud and the inducement. So, he has endeavored to prevent the population of these states for that purpose, obstructing the laws of for naturalization of foreigners, refusing to pass others to encourage their migration hither, and raising the conditions of new appropriations of lands, right? Acting outside of the scope and authority of the emoluments, the mechanism with which we have already acquiesced as to what we're going to follow when it comes to transferring real property from person to person, or family to family, or business to business, right? So we get into fraud in the inducement, right? I think I covered this a little bit, but it's very, very important, so I'm going to cover it more than once. This is a fraud occurring when a misrepresentation leads another to enter into a transaction with a false impression of the risks, duties, or obligations involved. An intentional misrepresentation of a material risk or duty reasonably relied on, thereby injuring the other party without vitiating the contract itself, especially about a fact relating to value or ability to perform. So again, when you get into stuff like this, you've we're talking about, an inducement is an inducement to get somebody to believe something that, the person who's who's making the claim knows is shift made up, right? So in criminal law, this is a misrepresentation designed to elicit a person's consent to sexual activity, but not concerning the nature of the activity itself, and therefore deemed not to vitiate any consent thereby secured. So wait a minute. See, this is when I kind of have a little bit of a problem with, because that kind of leads me to believe that somebody is going to say, well, yeah, I, paid for this, this hooker person. And so I paid her the money and then I roofied her. And that's okay. I don't think that's okay. Somebody else seemed to think that that was okay at some point in time. I disagree with that, but you guys can leave your opinions in the comments, but that's just my feeling on it, because, again, going back to the quid pro quo, an action or thing that is exchanged for another action or thing of more or less equal value, a substitute, right? So, that's why I said this is, we get into this one here. Here's a fraud on the community. Many of you family law people will know and understand. In a community, in community property state, the deliberative, this is such as like common law state. I'm sorry, not common law states. They're Pennsylvania, Kentucky. What are those? Damn it! Now I can't remember.
Say that again.
States like Pennsylvania, Kentucky.
Commonwealth.
Commonwealth. Thank you very much. So, That's what this is talking about. In community property state, which is Commonwealth states, the deliberate hiding or fraudulent transfer of community assets before a divorce or death for the purpose of preventing the other spouse from claiming a half interest ownership in the property, right? We see this a lot, and I mean a lot. And here's the one that I know everybody has been itching for. Fraud on the court, right? This is the one everybody's been waiting for, and I know it because I keep getting emails on this. So here's what the dictionary says about fraud on the court. In a judicial proceeding, a lawyer's or party's misconduct so serious that undermines or is intended to undermine the integrity of the proceeding. Examples are bribery of a juror and introduction of fabricated evidence. This is right out of the dictionary, right? Mm-hmm. So when I said, well, let's talk about the Bullock case. Let's run down through the Bullock case, right? Because in Bullock, the judiciary has given us a completely different definition. Here's what Bullock says fraud on the court is. This is from 1985. Fraud upon the court is fraud which is directed at the judicial machinery itself and is not fraud between the parties or fraudulent documents, false statements, or perjury. Not according to the dictionary, it's not. The dictionary says this statement is shit made up. So, again, however, there are parts of this decision which I will agree with. It is whereby the court or a member, right, is corrupted or influence is attempted, or where the judge has not performed his judicial function, thus, where the impartial functions of the court have been directly corrupted, right? So, again, you know, the first section, the first segment, first sentence of this opinion, you know, knowing and understanding that I was going after this business plan, Title IV, as what it is, Sharia law. Whine and complain out there all you want, but that's the reality of it, right? I put this forward out there, and nobody has said, no, it isn't, except, of course, those who are trying to fraudulently use it. But I digress. So, because the reason I chose this particular instance is I said, we're going to bring the judiciary in here because I believe this fraud, quadrant 4 of the litmus test, is an attack on the judicial machinery itself because it is not Republican either character or form, right? So again, choose your battles, right? Do you want to fight or do you want to win? I know that, you know, everybody, common observance is exactly what this definition says right here. So, you know, if you want to quote this and Bullock and go in there and say, look, there is a difference between what the dictionary says and what the court has said. This is a good reason that we want to come in and talk about what the hell kind of fraud are we talking about here? Because somebody's making some smew up somewhere, right? So again, that gives you a good way to go into a judicial oversight quorum and say, hey, you know, I got an issue with this because the court says this, but the dictionary says this. We got a problem here, right? Domestic violence, of course, you know, the law says this, and the jackwagon and, you know, with the bar card says something completely different. So then, of course, we get into fraud on the market, and I'm not going to spend a whole lot of time on this because, again, this kind of goes into corporations and marketplaces and stocks and bonds and all that crap. So, again, same thing, fraud on the patent office, right? We don't get into much patent work here, but I went ahead and left all this stuff in because she took the time to to scan it all and put it all in there. So I want it out there for those available. For those of you who might be working on patent cases, take your screenshots and that kind of stuff. So if you don't have access to a Black's Law 11th edition, you do by course of this video. So healthcare fraud, okay, from 1972. So we also know that the Obamacare, again, the exact same mechanism as Title IV. So do we need to maybe go through here and work on this definition a little bit? Maybe there needs to be some kind of foreign emoluments protection added into this, pillars of law, shift made up that doesn't exist in our government, right? So a healthcare provider's false statement or misrepresentation made in order to claim a higher payment for healthcare services than the provider is actually entitled to, right? Oh yeah, I gave them 6 shots and a beer for that ogle of the bogle, and the only thing they gave you was the beer. So yeah, why are you billing for 6 shots, dude? So better bring that bottle of Jack Daniels back over here, bro. Right. So
right.
Now, intrinsic fraud. Remember, we said people get a lot of these things confused. Here's another common misconception: the difference between intrinsic and extrinsic fraud. Well, we talked about extrinsic, so let's talk a little bit about intrinsic. Intrinsic is fraud that pertains to an issue involved in a judicial proceeding. For example, examples include use of fabricated evidence, perjured testimony, and false receipts or other commercial documents. Right? Somebody wrote a document and says, "Oh, I'm a corporation, but yeah, here, sign this anyway." That's a commercial document. That's a money transfer document. That's an example of an intrinsic fraud, right? So those orders that you're looking at, right? They're not in proper form. Don't have all the proper documents. They're based on a process that's foreign to our form of government. There's an example of a good intrinsic fraud argument, right? So, oh wait a minute, legal fraud, which is fraud in law. Okay, long firm fraud. This is an act or the act of obtaining goods or money on credit by falsely posing as an established business and having no intent to pay for goods or repay the loan, right? We see this a lot with, in malls, right? And, various other, concourse businesses, they show up, they collect their money, and then they're gone like a thief in the night. And then, of course, mail fraud. This one here is an act of fraud using the U.S. Postal Service, as in making false representations through the mail to obtain an economic advantage. Well, I think there is a little more to mail fraud than that. And there is plenty of stare decisis that shows that what people would say, well, they sent that to the wrong damn house or the wrong address. That's definitely, I would classify that as mail fraud, and the court has agreed.
Is that versus female fraud?
Right.
Oh.
So, and of course, we get into Medicare. I don't know why that is actually in there twice. Somebody's CD skipped when they printed the Black's Law 11th edition. Found our first, what is our first error in the Black's Law 11th edition. Remember, you folks, you heard it here first. Medicare fraud. So, promissory fraud, we went through this a little bit. A promise to perform made when the promisor had no intention of performing the promise, right? Somebody out there says, "Well, I'm going to build your house," and never shows, they take the money and never show back up. Yeah, there's one. And of course, wire fraud, right? There's an act of fraud using electronic communications as by making false representations on the telephone to obtain money. You know, that was we just talked a little bit about that. You know, those scams from what was it? What was that? Nigeria, wasn't it? So, let's see here. Was that frauderi or whatever? Roman law to defraud. So again, principles, badge of fraud.
Fraudery.
Right? Fraud dare ye or fraud dare you or whatever. So fraud by hindsight. What the hell is that? Oh, it's securities, right? Yeah. A claim of fraud based on the assumption that a corporation deliberately misled investors by issuing optimistic financial statements or forecasts and later reported worse than expected results. Again, this is corporate wrongdoing. See this a lot in markets, insider trading scandals, you know, a lot of that stuff. So I would kind of avoid stuff like this because yes, we know they're using bonds and all that other crap and money transfer, other types of money transfer documents or instruments, right? But I don't think hindsight fraud is applicable here. So, you know, again, we can get into the French civil law, fraude. I don't know if that's how you pronounce that or just fraud, right? Fraud. So, fraud committed in performing a contract. So, you know, this is what I say. It's you want to add an E to it, make it look French, cool, right? It's up to you. So fraud in the market principle, again, more corporate stuff. A lot of antitrust involved with fraud on the market principle. This again is, you see this a lot in corporate. Fraud on the power. This one's kind of interesting. Wills and estates in particular. An appointment of a power made in favor of a permissible appointee, but ineffective because the donee's purpose is to benefit an impermissible appointee. They may have a conflict of interest. Candy, I think if you're watching this, you may want to pay particular attention to that fraud on the power. Fraudulent act, conduct involving bad faith, dishonesty, a lack of integrity, or moral turpitude. Conduct satisfying the elements of a claim for actual or constructive fraud. Chime in here a little bit for me, bro, because I know you've been itching for me to go over this one. So
you're talking about fraud? What? Guess what I'm posting right now as we speak? The executive order on establishment of the task force on market integrity and consumer fraud.
Imagine that. We have an executive order for that.
Here it is. Here it comes. There it is.
Dun, dun, dun.
There you go.
So again, this is what I say. You know, this is, as many of you have probably figured out, there is now you're starting to know and understand there was a reason I've been avoiding this topic like the plague, because, you know, when you start going down through some of the comments, I mean, some of the comments are, you know, actually kind of belligerent, but, you know, again, I would be very, very careful about disparagement, right? So, fraudulent act, right? You want to use that, page 25, section 16, right? There, right? That's a good way to articulate what a fraudulent act is. This, I would screenshot this, make copies of it, staple it to everybody you think that this sucker applies to, right? Because remember, fraud vitiates everything, and so does what? Bad faith. Somebody acted in bad faith, and there you go. So, fraudulent alienation. Okay. What does that mean? Are we talking fraudulent Martians? I mean, what the hell are we talking about here? So, this is the transfer of an interest in property with an intent to defraud others. Oh, especially creditors or and lien holders. This could also be shareholders, by the way. We see this a lot in corporations. So the transfer of an estate asset by the estate's administrator for little or no consideration. And, again, having dealt with, lots of corporate wrongdoing and some of the crap that goes on. As I said, these guys are just stupid, ridiculous. A lot of it we end up in dealing with loss prevention departments and banks because of, just a lot of the crap that goes on. But the fraudulent banking, the receipt of a deposit by a banker who knows at the time of the deposit that the bank is insolvent. So, again, somebody who's claiming to be a bank that ain't a bank. We saw a lot of this back in the what was that? The savings and loan scandal, right? So if you guys want to know more about fraudulent banking, go back and read the savings and loan stuff, right? Where Fannie Mae and Freddie Mac took a real big hit back at that time. So, let's see here. Fraudulent claim. A claim for any benefit or payment based on a fraudulent misrepresentation. Right? Yeah, I should have attorney's fees because I filed a paper that says motion to dismiss for failure to state a claim. Did you go back in and review the case and, why the hell were you even hired to begin with? Or maybe you didn't file a motion to dismiss for failure to state a claim and now you want your attorney's fees anyways because you drugged this son of a bitch through the mud for, how many? I've been doing this shit 10 years just in this one case. How long? I'm afraid to ask how many people out there have been doing this at least that long or longer. Again, fraud in the concealment. See concealment and concealment rule, because fraud and concealment are very closely related, but they are very different things. And of course, conversions, fraudulent conversions, you want to go into specifically. This goes into money transfer documents and again goes back into the fraudulent banking stuff. So, be very, very careful about using those types of things as, something viable depending on what you're talking about. Conveyance, fraudulent conveyance. This is a transfer of an interest in property for little or no consideration made for the purpose of hindering or delaying a creditor by putting the property beyond the creditor's reach. A transaction by which the owner of real or personal property seeks to place the property beyond the reach of creditors. Okay, this is also true in the reverse. You go through and you make your mortgage payments and you've got fee simple title to that property. Where's my title? Same thing with a car, right? You paid off the loan to the car. Whether the loan was lawful or not, that's another issue. But the fact of the matter is you went through it, you followed terms and conditions, you met your end of the bargain, right? Where is my fee simple title? I don't want a certificate of title. I want my fee simple title. So again, if they give you a certificate of title instead of a fee simple title on real property that is recorded in meets and bounds, not lots and blocks, that could be a fraudulent conveyance, which you may have the ability to go back and say, yo, you better give me my fee simple title recorded in meets and bounds or your ass is headed to do some serious jail time because this is some smew. So, bankruptcy. Don't want to get much into bankruptcies and trustees and all of that because I could do a week's show on bankruptcies and trustees. So, fraudulent debt. See debt, specifically study debt. See joinder, fraudulent fraudulent marriage. Yeah. Bro, I think you've got that problem, don't you? Somebody got an action for divorce, but no contract of marriage.
Right. Yeah, I got all these actions for divorce, but never had a marriage
Yeah.
contract with the state.
I think we need to look into
Never
this
had
one for you.
with the state.
Yeah, right. I think we need to look into this one for you, bro. Just saying. So that could be under what? False pretenses? Yeah, okay. So fraudulent representations, of course. Now you get into representation. There's a difference between representation and misrepresentation. You're going to have to know the difference. Okay, because you're claiming that this person was representing me, paid this attorney $10,000, and come to find out your relief is going to be under misrepresentation. Misrepresentation or defective performance or defective practice. So, you got to be very, very careful how you articulate this stuff, because you don't want to end up down their statutory word salad rabbit holes. So now that everybody out there is starting to look like this guy, right?
Right.
I put this in there for good reason, because watching some of the comments, yep, I can pretty much tell that there's a lot of that going on. So don't feel bad. That's why I said, if you're watching this live, go back, watch it again. If you're watching it on the replay, go back and, don't be afraid to do some screenshots, do some, pull up some of the cases that are mentioned in the context of the dictionary definition, because this is always the reaction that I get when I start going into and using fraud and estoppel in context of, I always say, kind of like using a ratchet and a socket together. So because I know how to use a ratchet and a socket together, I'm pretty skilled with it. So now time to impeach their case. So what the hell does that mean? Well, where does sole power of impeachment come from?
The sole power of impeachment rests with the House of Representatives.
There you go, right there. Right? So you've got a bad case. You've got a bad actor in a court that is shit made up. Where do you impeach that? Well, again, go to Congress, the legislature, the House of Representatives. This is our republic.
This is due process of law.
Yeah.
The law of the land literally means due process of law. So
exactly.
All processes are in the Constitution, whether to bring the president into being, how we elect them, all these representatives in their positions of emoluments comes from the process laid out in the Constitution.
Right.
It also lays out processes for removing them from duty or
Correct.
dealing with, bad policy created by them.
Bad policy created.
That process is listed
right.
in that due process of law Constitution.
And God, am I so glad. Before I jump into this, I am so glad you brought that up, because I wanted to talk about this, because policy is supposed to be created by the legislatures that we elected into office. Mm-hmm. So why the hell is there a sub-agency, right, writing policy that they seem to think that we're bound to? No, you can't bind the people to anything. What part of that do you not understand? That is not a just power.
Where's the quid pro quo? In order to be a lawful contract, there's got to be something for something, the what for what, and it must be mutually beneficial, full disclosure, blah, blah, blah.
Right. These are established principles in law, right? I didn't make this stuff up. I just went and took a damn test on it. So, yes, I can prove I took that test. June of 1999, I believe, was the year. I think it was the 25th, wasn't it? I don't know. I'm not looking at it. Point is, knowing and understanding that, these agencies, these, word salad, alphabet soups, right?
Mm-hmm.
You know what the hell they're doing. The proper remedy is not in a court. It is in your legislature. Because guess what? Like I said, Watch what's going on in the oversight committee right now in finance. Finance is trying to figure out how to get a handle on this crap. But if you're not sending them documentation that's related to financial transactions, whether it be directly or through the Secret Service or both, I always recommend both. How can the finance committee call in somebody in the sub-agency of HHS or DHS or FUK or whoever if they don't have a petition letting them know there's a problem? And we don't do that through the court. We do that. We've all been misled to believe that that's done through a court. Right? So again, misapplication of the law. So because I said so does not constitute substantive due process, unless of course you're my mom or dad. So this is predicated on the legal maxim: we should follow our own rather than foreign law. Right? So, and of course, our own law is leading to a motion to expunge. That's a motion 39. And one of the reasons that I'm going to cite this, because we know that the crap that they brought forth is in some way frivolous, right? It is. It's crap. It's garbage. So if it can't be introduced, and this is the process for dealing with frivolous crap that is introduced, but even though it's after the fact, using this, making reference to this part of the process in the book. This is section 401, by the way. An amendment that is frivolous or absurd is not in order, and the presiding officer may refuse to state amendments that, in the presiding officer's opinion, are frivolous or absurd. So if you want to go in and you want to say, well, according to section 401, even the court has said this is ridiculous shift made up. Mm-hmm. So, why does the judge need to come in here and tell you this? Or who's coming in here and telling you otherwise? Because, think about the ridiculous absurdity of, this quote unquote clear and plain language of the statute, which is nothing but directory garbage only. They're attempting to apply this crap as law that they say is, this applies to you. Oh, bullshit, it does. Not in my republic, it doesn't. So either in my official or my personal capacity. Remember, I'm guaranteed a Republican form of government. So if somebody walked in here and lied to Congress, I want to know who walked in here and told the lie. I want to see the paperwork that was submitted with it that brought this into being, right? So they start getting enough of these things. Guess what's going to happen? They're going to go through and do exactly what Idaho did. What did Idaho do, Kirk?
Well, we basically, our governor at the beginning of session last year said all rulemaking from the executive agencies have been abolished.
Right.
Except for temporary emergency ones that he allowed to come through. But all rules have to be remade.
Yeah. And they got to start over.
They're still working on it.
Yeah. That's right. Because somebody claimed and exercised powers they didn't have. Right.
Mm-hmm. And now even our attorney general is sitting there saying, hey, legislature, the executive branch doesn't have the power to make this stuff.
Right.
You guys in the legislature need to make a public law regarding the agency's conduct and deal with it.
That's right.
That's what he said. I sat right behind him and listened to him say that. And I'm like, holy crap, who is this guy? Because that's the same crap I've been saying for a couple of years. It's like, come on now.
Maybe he's watching the show. Thanks, bro. Love you. So, So that's why I say, if you want to impeach something that is frivolous or you believe that is innocuous or improper, to cite the process that was supposed to be used to bring something like that into being is actually a justifiable use of a method of impeachment, right? Reverse their reverse,
Right.
Hold a mirror up to it, so to speak. So how do you impeach their SMU? Well, again, you've all seen the business plan. This is what a Republican business plan looks like, right? I'm Richard Cranium. I have this idea. Okay, I'm going to bring this before the body, right? In Congress and government, that's a meeting, a quorum, right? We're going to discuss these impact assessments. We're going to call in those agency people, right? All those departments. So, how many of those are in your state again, Kirk? 200 and some odd, 300 and some odd?
276, I think.
Right.
Constitution limits it to 20.
So, yeah, dude, somebody's like, somebody's wheels fell off of somebody's wagon. So, subject matter, right? That's a great way to articulate this. That's a great way for you to say that, Kirk. Look, the letter of the law. We're not even going to talk about the statutes. This letter of the law says we're only supposed to have 20 of these things. How the hell did we end up with 270? Somebody is extorting some money from us taxpayers here somewhere, bro.
And I go right back to that one. One of my most favorite ones from the Declaration of Independence: erecting a multitude of offices,
right?
Sending hither swarms of officers to harass our people and eat out our substance.
Amen, brother.
Right? Constitution is the supreme written will of the people. Why are you unlawfully usurping your powers and creating all these agencies in excess of 20?
Right. So
you are not authorized to do that.
That's right. You want to create one, you better get rid of one.
In fact, after what I have found, they don't even have the power to create agencies. They only have the power to create the public law regarding the agencies that the Constitution creates.
Right. And those things are subject to oversight at all times, which we have covered.
People. That's right.
Which we have covered implicitly.
Right.
So we go back to the history, the First Continental Congress, right? We didn't make this up. This was right out of Annals of America, right here. So, this concept is nothing new. So can they cite a corpus delicti or substantive due process or evidence of a crime for that matter, right? Are their arguments plausible? And under what law are they standing in? What pillar of law can they verify their standing? Right? So status, standing, jurisdiction. So you can impeach any bit of that at any time. How many cases has even the high court said? Hell yeah, you can impeach status, standing, and jurisdiction at any time. So to see the high courts coming out saying things like, yeah, these jackwagons didn't even have standing. Yeah. Now you're talking, because it's one thing to say there's no jurisdiction. It's something else to say you don't even have standing. So, that's why I say it's, when we say there's no standing, that means there's no just power. This is the reason I put it up here. What's the test for the law? Well, I created one of my own. This is from principles long used in loss prevention. So, I actually learned this technique from a guy who taught me loss prevention. That would be, oh, wait a minute, my old man. So, kind of give you guys the idea of, I come from a long line of, impeaching the SMU. So now, which manual are we talking about? Well, again, are you talking about jurisdiction 2 in commerce? Your state probably uses Masons. Are you talking about jurisdiction 1, defense? That's Jefferson's manual. I think there's even a couple of states that use Jefferson's as well, isn't there? Isn't Indiana one of them? I hear somebody talking there, but I can't.
Oh, sorry. I just got sent this video. Warrior against child trafficking arrested by deep state. This is David Zublick channel.
Oh.
I've seen the videos from this guy before. I don't know if that's actually David Zublik that's on there, but yeah. So information's getting out.
Right. So again, you're going to want to know which manual applies, right? Now, remember, substantive due process. You would at least want to be able to show that you attempted to resolve the issue at the state level first, right? I've answered many an email on this, and the reason for doing this was because, well, if you're going to want to go to DC, DC is going to say to you, what did you attempt to do at the state level? What process did you follow? That's a justifiable question. I would want to know if I were sitting in that position of emolument. Oh, working in my position is, being a boss, somebody come to me and say, this is too hard. I don't know if I can do this or not. Did you try? So,
a lot of times we're hearing things like, oh, well, my legislature is corrupt. Why,
that's a defeatist argument. I mean, if you want to be
people to quit being self-defeating, things have changed. We have a new administration, whether you like Trump or not, whether you think he's bad or not, start following due process of law, because this is our government.
Right.
We have the right to petition the legislature for the redress of grievances. Right. We have the right to alter, reform, or abolish anything, capital T, at any time we deem it necessary. But you got to follow the process that's due to make that happen.
Right. So, and again, this was just how this evolved. You guys have watched many of our videos, so I'm sure you've seen this. So as we go back through the conduct of a tyrant, right, for transporting us beyond seas to be tried for pretended offenses, for abolishing the free system of English laws in a neighboring province, establishing therein an arbitrary government and enlarging its boundaries so as to render it at once an example and fit instrument for the introducing the same absolute rule into these colonies. Right? Well, there's your Democrats, Smew. Right? There's your bar idiots.
Right.
That's that fourth pillar of the bar. So, taking away our charters, altering our most valuable laws, and altering fundamentally our the forms of our governments. There's an example of that. You guys out there going after Obamacare. They're trying to claim Article 1, Section 8 and Article 4, Sections 1 and 2 as, oh, yeah, we can justify this. Hogwash. Does that look Republican in character or form? That looks like one of them malicious designs to me. By the time they're extorting the insurance billing codes, that's exactly what they're doing.
Right.
They're using doctors and vaccines to create the harm, right?
And well, I love how you break this down right here with these pictorial graphs. It's like there's so much information right here and explains so much in just a little picture.
Yeah. Well, it's my intention was, like the old man says, put it in the clear and plain language that something, somebody can pick this thing up, look at it and go, holy shit, what does this thing supposed to do? And the answer is, well, this is supposed to be government. Wait, what? That's not what our government looks like. Well, according to these Democrats, these entitled people, these socialists, it is. Mm-hmm. Well,
hey, there's the negative nexus in there.
Yeah. Right. Those health.
Just so everyone knows, -1 times a -1 actually equals a +1.
Correct.
Mathematics.
Those are two fundamental principles of law and algebra, in mathematics. So, the reason
now,
I'm
a -1 plus a -1 does not equal a +1.
No,
that equals a -2.
Correct. So, because now you're talking about the order and the operation being performed. So, when the operation is civil in nature, but they're converting it to criminal in nature, that's where we go from addition to multiplication. So the effect is magnified, right? So hence the reason I use multiplication instead of addition when I build these models, because that's what they're alleging. Everything is criminal in nature. And again, going back to, the Patrick Henry speech, I popped this in there for those of you guys who missed our Veterans Day show. Sir, we have done everything that we could that could be done to avert the storm which is now coming on. We have petitioned, we have remonstrated, we have supplicated, we have prostrated ourselves before the throne and have implored its interposition to arrest the tyrannical hands of the ministry and parliament. Yep. Our petitions have been slighted. Our remonstrance have produced additional violence and insult. Our supplications have been disregarded, and we have been spurned with contempt from the foot of the throne. In vain, after these things, may we indulge the fond hope of peace and reconciliation? I would say, I think not. So, and of course, here's the rest of the speech. And, at the end of this, where, it says, he took his seat. No murmur of applause was heard. The effect was too deep. After the trance of a moment, several members started from their seats. The cry, "To arms!" seemed to quiver on every lip and gleam from every eye. These guys were happy as hell to go to war over tea. This was tea they were fighting over.
The tax on the tea.
Yeah, the tax on the tea. Are you freaking kidding me?
But you got to remember what they were going through at the time, just prior before that.
Just what I'm saying, dude. So, we talk about, where do these lists, you looking at your list of motions, where does all this stuff come from? Okay, that's the kind of history that led into what we're talking about right here and right now, right? So, that's why I said this is just another rendition of this same historical shit show. So, where does this end up? Do we end up in another version of the Crusades or something? Oh, hell if I know. Don't ask me. I don't have a crystal ball. That's beyond the scope and authority of the emoluments of my office. Sorry, guys. But, this is the, I actually found earlier too, maybe I'll go through it if we have time, where the list of motions is actually broken down way beyond this. I actually did find that section in the book. So, again, this is an example of my cover letter, right? Where I've said, this is what we want you to do. Investigations in public order. Okay. You want an investigation into something. This is the process of how you get there. Mm-hmm. You pick up the phone and you call your legislator, and I guarantee you will start getting phone calls from prosecutors. I know I do. So the fact of the matter is in most of the time, it's not that they're, at first they're very off-putting, but by the time we get to the end of the call, they're like, now I see why I was ordered to call you. This is some stuff I was never taught, or maybe I was taught years ago and never thought about, never remembered. It's like, well, hey, we're there, bro. You think I don't have better things to do than to go back to my office? So what powers do they have to do this? Well, again, show them the book. Which one of these, where does that come from? Where does their oversight authority come from, and why? So investigations respecting any members, right? You got information that there may be a bad actor in Congress. There's a process for that. limitations on right of a legislative body to investigate, right? They got limitations too. They can't come into your house. The only thing they can come into is they can investigate the actors who came into your house unlawfully. That's their job. That's what we want them to do. So, the method of investigation by a legislative body. So, again, sorry guys, I don't mean to be rude. I'm reducing these private messages because it's hard to see comments. So the method of investigation by a legislative body, again, in cases where anonymity, I think, is important because of the sheer nature of the horrendous nature of the crime. Legislative investigating committees. Okay, you want to assemble a quorum that's going to investigate specific things. Maybe you might want to get together and put together a subcommittee and say, hey, collectively, we've put together a list of criteria that we've noticed as a pattern of behaviors. Okay, maybe these are some of those red flags you guys need to be looking for, right? So, again, many of you out there are very smart. You're very intelligent, and you're very capable of doing this kind of thing. What you've been missing is how to bring that thing into being. That's what we want you guys to know, is how to bring that thing into being and why. So, witnesses in legislative investigations. Okay, there's an entire process for being a witness in a legislative investigation, as we're watching right now in this Schiff made up impeachment inquiry. So, so again, we're talking about the Foreign Emoluments Clause, Article 1, Section 9, Clause 8, and the 13th Amendment. Well, you don't think that they have to acknowledge the Five Eyes intelligence exists. So the quid pro quo was the contract, the deal that was signed, by people that are now long since dead. We're going to do away with that shit. Tell the UN, say goodbye to the UN for me if you're in New York, because I don't think they're going to be here much longer, or at least not in their current form. So,
right.
Compelling witnesses to attend and testify, power to punish for contempt. So, what is contempt, right? If they're going to hold you in contempt of Congress, they better be able to. Now, there's an in-camera meeting. So they better be able to show that you did something that was contemptible if they think they're going to hold you in contempt. Summonses and subpoenas and warrants. Okay. Right of an investigating committees to sit between sessions. Right. This is actually a good idea, especially when we're talking about financial mechanisms, because I would think that the Finance Committee would want to have representatives in the Judicial Committee to say, well, what the hell is the court saying about this? Because I'm going to have to go back in and write all new programs, write all new guidance for this. So I would want to know what the judge says. So I would think that the Judiciary Committee would want to welcome somebody from the Finance Committee, and come to find out they do regularly. So just know and understand, but there's a process for that. If you got somebody, somebody that's on finance, you say, hey, can you go poke your head into the Legislative Committee for me? I don't know if I can do that. Yeah, certainly. Page 576, Section 803. You can certainly do that. Oh, really? I didn't know I could do that. So this is one of the reasons, again, why the state appeals court, they granted me standing to do this, because they know I'm not out there busting the judge's balls. I'm always out there saying, thanks, guys. You're giving me everything I need to go in, provide oversight, and shut this crap down. I wish somebody would have asked me sooner, but I'm doing the best I can. I mean, no matter how crazy it seems, my freaking fingers hurt from typing all the time, but I digress. But the point is, hey, we're making it happen. This is not a job I wanted, but it's a job that I got stuck with. And we're going to do it. Whether either one of us likes it or not, we're going to get to the end of this damn thing, knowing that expungement's going to be the end result anyway. So, yay. So, you got to remind them who's driving this boat, where can they find your standing, right? What will any and all discovery and disclosures look like, right? So, and of course, how do you make that happen? So, if you're going to go in and you're going to cite what your standing is, they're going to pull that, it's sovereign citizen, sovereign citizen. I don't know what the hell a sovereign citizen is, but I know my authority is sovereign. I can point to that. I can verify that for you, right? So here's where you'd verify that. So what you just did is you just took their whole sovereign citizen shit and punched them in the mouth with it by proving a contrary positive, right? Proving a negative with a contrary positive. Calculus. So can you articulate why? To whom? Well, in a quorum, you have to know how to assemble one of those, right? Assembling a quorum is not an easy thing. I mean, there are criteria for even computing a quorum. Okay, so if you're talking about you want to go through and you want to convene a quorum to oversee CPS, for example, you might want to know this section, and know what it means to follow the process. Have the book with you and say, look, according to the book, we can create a quorum to do this. Remember that criteria, those talking points we've talked about? So to have that in front of you, to go in there and sit and meet with these guys and these girls, whoever, that's not a bad thing, right? So, you're showing them this is not about who's is bigger now. This is about what are we going to do to fix the problem. So you already know the lawyers are trying to say whose is bigger. Well, theirs is out to sea. So if you're any guys out there who have ever been to sea, you know what I'm talking about when you hit the cold water. So we'll just leave the whose is bigger at that. So, right. But anyway, I digress. Who may be counted when determining a quorum? Because again, if you don't know this, you don't want somebody in there, if there might be a potential conflict of interest that even they don't know about. Right? So, that's why I said you could end up in compromising yourself before, you even get into stuff like this. So that's why I say, pick up the book, read the book, know and understand how these things work before you go saying, this is fraud, this is intrinsic, this is extrinsic, this is fraud in the factum, and da-da-da-da-da. You can walk in and they're going to look at each other and look at you and they're going to go, man, this dude sounds like a blubbering idiot. So before we go, I'm going to do a little bit of let's recap some of the important questions here. So, do you know your standing? Okay, it's important. Do you know what the affirmative defenses are and where the most common places are to find them? Okay. Is performance a relevant question, and why? Okay. Are we talking performance of a bar member? We talking performance of any government actor and any specific emolument? Okay. So, again, don't think of performance just as an attorney or a fiduciary. Performance is anybody in position of an emolument, anybody receiving a stipend. Remember, Bill Barr's answer to my parliamentary inquiry. If they receive a stipend, they are subject to performance requirements. End of discussion. If anybody disputes that, you can come and tell them I sent you, because we know better. Can you articulate why? Okay. And of course, who can or cannot participate and why? So these things are very important, right? Some of those finer points you may want to make note of. Do some of your preliminary research, because as you go down through your document and you start picking some of these things out, it becomes more important to say, well, hell, what I believe doesn't matter. What I can prove is what matters, right? So this is the stuff I need to talk about, what I can prove. So, and again, I'm going to recap Rule Federal 8C, accord and satisfaction, arbitration and award, assumption of risk, contributory negligence, duress, estoppel, failure of consideration, fraud, illegality, right? Fraud could be any illegality, injury by fellow servant. As a person in position of emolument, I'm potentially subject to that. Latches, license, payments, release, res judicata, statute of frauds, statutes of limitations, and waiver. So who does this stuff apply to and why? So, and this video has been brought to you by Kirk's Law Corner and E-Clause Loss Prevention in conjunction with our support staff. One of these days, girls, I'm going to have you come on here, and I'm going to want to introduce you to everybody out there and let them thank you personally for all the work that you do. With a special thank you to Tanya Davey. I went through and made some additions to the Teespring store. This is some of the stuff that she's done, and I've got some new stuff in here. Loss prevention, the T-shirts that Kirk and I wear. You guys can get one of those T-shirts now. Here, you can find them in the store. Kirk's is the same thing. I got a brand new coffee cup, the Keep Your Doctor coffee cup, with the diagram on it. It's with the for you people out there who are fighting the medical kidnapping and healthcare fraud SMU. We got right cannot die. That's a maxim of law. And of course, the loss prevention shirt and pants and all that. So if you guys want to send out a personal private donation, either Kirk or myself, you can send it to this address here, 6477 West Fairview Avenue, Suite C, Boise, Idaho, 83705. That takes care of Kirk and, of course, myself. 16062 Southwest 34 Court Road, Ocala, Florida, 34473. And those who wish to just do cash, PayPal or Cash App, here's the information for that. We do appreciate any assistance you guys do help us out with, because again, I just dropped in I'm getting ready to say I just dropped in another almost $200 worth of stuff, and I've got more, about halfway printed now already, and that's going to be even more than the previous set of documents that I went through that I just dropped in. So it's going to be a zoo. So on that note, I need to I got to go see 3PO for all this tea I've been drinking. I think I'm about to drown in my teepee. So I'm going to go in here and stop the screen share. Oh, I think it already did that automatically. Maybe possibly could be. Or did it? Did it do that?
Yeah, it stopped the screen